Committee come to order.
Thank you, Mr. Chairman. I appreciate the opportunity to address the subcommittee. My name is Carlton Greene. I'm a partner at Crowell Moring. I'm formerly the chief counsel of FinCEN, and before that served a number of years at Treasury working for the Office of Foreign Assets Control on sanctions activities against U.S. sanctions regimes against Iran, North Korea, transnational criminal organizations, and terrorist actors. Since leaving FinCEN, I've been now 2 years in private practice working in the economic sanctions and anti-money laundering areas, primarily for financial industry clients, and I think it's given me a balanced view on the critical mission that FinCEN plays, but also the enormous efforts that private industry puts into complying with the Bank Secrecy Act, the burdens associated with it, how seriously they take it, and how much they work every day to try and comply with it, much of which is not seen by regulators. There's just a few points I wanted to make today. One is that I think the CDD rule represents a very important advance in the information available to FinCEN. Information on beneficial owners, I think, will allow FinCEN to draw all kinds of connections that were not previously available to it in the fight to detect and deter financial crime. I think that's critical information. I think that FinCEN deserves credit for having gotten this rule across the line. This is a rule that's been 10 years in the making. FinCEN conducted extensive public outreach associated with the rule. It incorporated a lot of the comments that industry provided. It showed a willingness to engage with folks and have a real back and forth dialogue. I also think that the FAQs that FinCEN put out again shows considerable responsiveness to the concerns that industry raised about the rule and the questions that they had about the rule. I think that kind of partnership bodes well for the future of the rule and its implementation. On the banking side, I think that banks and other covered financial institutions likewise put an enormous amount of effort into informing FinCEN's work on the rule, helping it to understand what kind of ideas would impose impossible burdens on the industry or otherwise wouldn't generate the kind of benefits FinCEN was hoping for. I know that the CDD rule comes on top of the many burdens that these institutions already face, and I know firsthand from my experience in private practice how much time, effort, expense goes into maintaining AML compliance programs, much of which is never seen by regulators. I know also that the professionalism with which every financial institution I've dealt with has approached this issue. So I think there's a lot of credit to be given on both ends. A few points about the rule itself and about the future of the AML regime. I think the FAQs, although they provide important interpretive guidance and have solved a number of the problems raised by industry about the rule, there are a number of compliance questions that still remain out there, and I've given a list of several of these in my testimony. I think my hope is that FinCEN will continue to work closely with the regulated community to address these questions, to provide public guidance where possible on them, but always to listen and offer its thoughts on the approach to these so that industry knows the way to go forward and that implementation is reasonable and possible. I also hope that in the early years of implementing the rule that they will be lenient about enforcement, understanding the inevitable but unexpected obstacles that will arise. The second point I wanted to raise is a broader issue about AML regulation and relates to FinCEN's relationships with the prudential banking regulators. One of the concerns I have, and I think I share with Mr. Baer, is that because FinCEN has delegated examination authority to the federal banking regulators, to the federal functional regulators, I should say more broadly, and because these agencies have use their own independent authorities to enforce Bank Secrecy Act obligations, I think there's some risk there that there will be divergent interpretations of the Bank Secrecy Act, or that enforcement priorities across all these different agencies will not necessarily line up with those that most advance FinCEN's mission of detecting and deterring financial crime. FinCEN, I think, is uniquely positioned in that it has access to financial threat information and it also understands the regulatory process. And I think it's uniquely positioned to balance those two together to ensure that enforcement is calibrated to the actual needs to address financial threats. In the absence of that dual knowledge, I think there's a potential for overly formalistic enforcement of the Bank Secrecy Act. I'm happy to comment further if needed.
Thank you, Mr. Greene. Appreciate your testimony. With that, we'll begin our questions. I'll recognize myself for 5 minutes. One of the concerns that we've had, and Chairman Pierce and I are working on a BSA ML bill, and part of it is to get this beneficial ownership situation resolved. One of the problems that we see is that the banks are being deputized to become law enforcement officers by this rule from Treasury, and it's costing literally millions and millions of dollars. One large bank I was talking to actually has over 1,000 employees that do nothing but take care of BSA, MLL, and now they're going to have to deal with this beneficial ownership situation. So, Mr. Greene, you tell me that you've been involved with FinCEN for quite some time, and you kind of like the rule, according to your testimony. Can you tell me, do you think FinCEN could be able to collect the information by themselves? That's what we propose in our bill. Is that going to work or not?
Thank you, Mr. Chairman. If by that you mean if they were to collect beneficial ownership directly themselves,
right,
and to make use of it, yes, I think that is a possibility.
That's a viable solution. Is that what you're saying?
It is potentially a viable solution. Yes, sir. And I also think that speaks to a separate issue, which is that there's only so much that financial institutions are in a position to gather. Putting aside the burden just as a practical matter, I think Mr. Baer mentioned some of the circumstances that, as useful and as important as the CDD rule is, there are types of information, companies that will not be covered by it in terms of beneficial ownership information. And that would include, for example, an LLC that's established in Delaware but keeps its accounts overseas and directs its operations overseas. That would not be covered by the CDD rule because it would not be banking with a U.S. financial institution.
I had my taxes filled out during about a month ago, and I asked my accountant. We had this situation, this problem, and I said, is there another way that FinCEN could collect the information? And he said, IRS already has all this beneficial ownership information. And since IRS is within the Treasury Department, which is where FinCEN is, you would think you would be able to just give them a call and say, hey, can you give us this information with regards to XYZ company? Is that a viable solution?
Thank you, Mr. Chairman. I have not, I will confess, I have not looked at the specific beneficial ownership information available to the IRS. I do know that in the past there have been legal impediments to using taxpayer information for purposes of financial threat analysis on the FinCEN side.
Okay, but according to my accountant, they already have this information because you have to file it when you file your tax returns. And so if we could do something in the bill, for instance, to say something to the effect that we would allow FinCEN to have access if they have some sort of cause to be able to go looking for this information, would that be a viable solution?
Certainly, I think that FinCEN could make very good use of any beneficial ownership information that might already be in the government.
That would certainly streamline things, wouldn't it?
When we're talking about money laundering, do you have or know or understand information about what's going on with Cyprus and its role in, money laundering and shell companies?
Yes, thank you, Congresswoman. I would just say that I think Cyprus has been an attractive jurisdiction for a variety of actors because it's seen as a favorable jurisdiction for offshore banking and also one that protects the privacy of companies that are established there, sometimes referred to as bank secrecy jurisdictions. And I think you can see that sometimes that can go awry, as has happened in the recent designation of FBME by FinCEN for 311 sanctions.
Thank you. You're back.
Wow. Does anyone review the CTRs? Are they just kept in a database to be used if there's a lead that comes up? And if nobody's reading them, does it make more sense to just have the banks keep it and make it available should somebody need it? Or if people are reviewing the reports, for which I haven't received much evidence, indications otherwise, and acting on leads that they generate, what can we do to demonstrate to the people like Ms. Martinez that all of their time, effort, and money devoted to this is actually making a difference? That's a big mouthful of questions. Mr. Greene, you win. 1 minute and 16 seconds.
Thank you, Congressman. I appreciate the opportunity to answer this question, having been inside FinCEN and seen the value of SAR reporting. I think you touch on an issue that FinCEN, I know during my time there, was very concerned about, which is the lack of feedback about the value of SARs and their utility. I can tell you from having seen inside at FinCEN, SARs are immensely useful, and so is a lot of the other reporting that is required under the Bank Secrecy Act. I was particularly impressed by their use in combating terrorism and in informing investigations related to terrorist attacks, both within the both abroad and also activities within the United States. And so I think they play a critical role, but I think that there is some regulatory fatigue that has set in among the regulated financial institutions that have to comply with the Bank Secrecy Act, and they need to understand the value of those SARs, number one. So it would be nice to have some method of feedback to industry to explain to people when a particular SAR has been useful. That would require some collaboration with law enforcement. But more broadly, I also think there needs to be some flexibility in the approach to enforcement of the BSA requirements so that we're really focusing on enforcing against parts of AML programs that really address the particular threats that the country is facing at any given moment. Thank you.
Thank you, sir.
As we all know, the May 11th implementation date of CDD Rule is rapidly approaching, as we've talked, and however, FinCEN earlier this month released an additional set of FAQs to assist institutions in compliance. So do the recent FAQs give institutions the needed clarity to meet compliance standards, or does FinCEN need to offer technical corrections or the other changes to the regulation?
Thank you, Congressman. I think that the FAQs take care of a number of the questions and concerns that industry had raised during the 2-year period where they had a chance to kind of work on implementation to the rule. I do think there are some questions that are still outstanding, and I think that that's going to require close collaboration with FinCEN to get those questions answered, and that FinCEN needs to address those and provide extra guidance where needed so that institutions can meet their obligations. I also think that during this, once the May 11th implementation date arrives and they go forward into implementation, FinCEN needs to demonstrate some leniency and flexibility with the inevitable issues that are going to arise as people start to implement. Even if they were to resolve tomorrow all the issues that are raised by the FAQs, there are going to be other issues that arise as people start to actually implement these rules, and they just need to be patient and flexible, as Mr. Coleman had suggested. Thank you.
I yield my time back. I'm grateful for your all's testimony. Thank you.